25 years of family law, a little bit of crime, lots of civil stuff, civil litigation, insurance matters. Property was a key to what we did. It's a key to a small residential practice. Tax, I was a tax agent for 40 years. Because historically, lawyers provided tax advice and did tax returns. It's only been in the last 30 or 40 years, it's been estates. There have been a couple of doozies. There's one which I'm in the process of finalising now, which has been going since 2016. We got a Court of Appeal decision at the end of last year in our favour. And essentially it was a second cousin disputing the will of his second cousin. The one thing he did have was motivation and money. So he was able to essentially cause the estate 9 years of expense.
The legal system and how it provides avenues for remedying certain situations. But because those avenues are so wide and people are able to run their claims as they wish, I guess there'd be an issue with limiting people from running claims in the first instance. But the negative side of that, the flip side of that is you can really run costs up.
And then, of course, you come to what happens if someone has super but no family. Well, the ultimate beneficiary is the estate in superannuation. It's just that there's a hierarchy before that. So you can, depending on the structure of your family and who your dependents are, you can pick and choose who gets the super very effectively and very simply.
So I'm here sitting with Gerard Pander. Gerard, it's great to have you on the show. And I think there'd be a lot of people that are curious here to kind of hear about your story as to how you were first introduced to the law. So tell us a little bit about your upbringing and how you came to the law.
Hayder, I'm a third generation lawyer. So my father and grandfathers were both lawyers, small family practice in Ipswich, where I am today. And I suppose my father was interesting. He was never one to push me to do what he thought I should do. He let me find my own path. So I suppose, when you have a family business like that, you work in it from an early age, as I did. We all worked there in school holidays, my siblings and myself. And eventually I thought, well, maybe I'll give this a go.
Was it something particular that you were attracted to in the working in the legal practice? Or
No, not at all. In fact, just the opposite. It took me probably 2 or 3 years after I left school to really start to enjoy it, to really think, well, maybe this is for me, maybe I've got some skills here, maybe I've got something to offer. Because initially I did it because I didn't have anything else that I could think that I might do, even though there were many options, of course. But so I sort of gradually worked my way into it and found that I liked it.
Was there a point where you feel like it clicked for you when you started working in a particular practice area? Or
Yeah,
was
look,
there a client?
Look, I think it was a small practice. My father had no other solicitors, about 3 staff. So, you had a lot of interaction with clients. And when you actually started doing that, when you actually started providing advice, when there was an expectation you'd actually carry some of the load, I think I found that I really enjoyed that. And I enjoyed the client. And one of the things I've always enjoyed about this job is the client communication, the ability to talk to people. And you're not always successful. You provide advice. People sometimes take it, sometimes don't. But you're in a position to influence people and influence sometimes important things that happen in their lives. And I think that's a very privileged role to have.
And of course, over the years, you've had many clients, some that have stuck with you for many years and some that have come through intergenerational, let's say, referrals. Tell us a little bit about that and how it feels to kind of see the life cycle of a client play out.
It's an interesting thing. I still have clients that come in today who knew my grandfather. Now, he died in 1946. And so these are obviously elderly clients who were young at that time, but they'll come in and tell me about him. Now, I never met him. He died 10 years before I was born. So, and my father, and of course, my aunts worked in the legal practice. My mother worked in the legal practice at different times. So it's really more than just a job, more than just a family business. It has tentacles everywhere, if you like. So it's really interesting to see and listen to those people who tell you about your relatives that you didn't even know.
Yeah.
So that's a privilege. It's a privilege to have that.
Yeah, it is, and a fascinating experience. And your family's always kind of been linked to Ipswich, and I think it would be a fairly well-known family and brand and business in the community. What does that mean to you, and what have you seen happen over Ipswich throughout your lifetime?
Look, it means a great deal to me at a personal level, not only at a professional level in terms of the advice you provide and the service you provide, but also I live in this community. I was born here and I probably die here. You're plugged in. You are integrated into a community. And even if you don't want to avoid it, you can't. So you have to sort of live live all of that together. So I think that's an interesting role to have. And again, it's something that grew on me. Took me a number of years to really get comfortable with that. And, since I've become comfortable with it, I really enjoy it.
Yeah.
In terms of change as well, I started working for my father when I was 17. As a student, I worked there before then. So that's 52 years ago. Lots has changed since then. I mean, obviously the computerization, the digitization. Today's buzzword is AI, which is going to affect all of us. So you just see enormous changes. And I suppose, again, I'm privileged to have had the perspective, what I think perspective on that, to know what it was like before you didn't have mobile phones, where having a phone was actually a privilege for many people. Many people in this community did not have phones at all.
Are we talking about telephones, fixed line,
Telephones at home, right? It didn't have them because this is historically a working class community. It's a little bit different today. And so to go from that to today's situation, people couldn't imagine life without a mobile phone, let alone without a phone at all. But it all worked. Society still functioned really well at a much more granular level and without the need of connection that we all seem to crave today.
Yeah, well, it would have been a time where there wasn't an expectation for instant communication.
No, that's right. Well, you couldn't do it. It just wasn't. Well, I'm sorry, I should say you could do it. If you had a phone, you could ring someone, but they'd be at work, or they might ring you back a day or two later. It was different. The pressures were different. So, today everything's instantaneous, as we all know, and some clients expect an instant response to their complex problem, and then can you have the documents done tomorrow? And or yesterday. And so you're constantly hosing down their expectation. And that's the reality of it. And that wasn't that way in the past. Still, it was still a pressurized environment, but not the same.
Yeah. Well, you do a lot of work in the community. Tell us a little bit about that and how you got involved and what you're involved with today.
Look, I suppose I've always had a view, even as a young person, that if you're going to live in a community, you're going to live in a place which is local. I mean, this is a fairly large regional city these days, but it used to be a lot smaller. So, I benefit from this community. My family benefits from this community. We should give back to that community. That's always been something I've believed, and I like to think that I've lived that in my community involvement over the years. Done many different things, been on many different committees. Probably the most significant is the Hospice in Ipswich, which you're aware of, which is a community-run, community-operated facility, not-for-profit, and I've been on the board there for 30 years. And to see that grow from nothing to a facility now which is contemplating a major expansion, I think that's just great stuff. And it is all about the community.
Yeah.
So
tell us a little bit more about that in terms of when it grew from nothing, like what actually nothing was and where it is now and the type of work that they do there. I think it's really important.
So the hospice movement started sort of in Europe and the UK in the 1950s and 60s, got to Australia in the 1970s, got to where we are in the 90s. And there was a volunteer part-time service provided by people in the community, usually with medical or nursing backgrounds. And that grew, and there was a particular individual called Hilda Desart, who was of mixed English and German heritage, who emigrated here in the 90s because she decided that this city had everything that she needed, and she was a force of nature. And she started a hospice movement in this city, which then established a 6-bed facility, which is what we currently have, and we raised at that point 600 community. And that was unheard of. No one had ever done that before. Nothing like that. And so now we're going up a couple of orders of magnitude in what we hope to raise to expand the place significantly.
Yeah. And what, for those that don't know, what is a hospice? What's the work that they do there?
Hospice essentially looks after people in the final stages of life. It's a version of palliative care. People can be palliative in a medical sense, but it might last days, it might last months or years. Whereas hospice is more about the actual end-of-life stage and having a facility where people can die or spend their last period on this planet in a home-like environment, not in a medical facility, not in a hospital ward or a nursing home, where there's a great flexibility around family visiting, where we make it as non-clinical as we can and as home-like as we can. And there's a real demand for that.
What would be an example of a person that would use these facilities?
The demographic varies, but obviously it's usually an older person, often with a cancer illness, but not always by any extent. Someone who isn't going to get to a nursing home isn't appropriate for a nursing home. Someone who's going to die in the next 2-3 months or 2 or 3 days sometimes, and where nursing home care isn't appropriate or isn't going to happen, and where the alternative is hospital or the home. And while most people want to die in the home, the reality is that's a very difficult thing to do from a personal and family perspective, and also from a support services point of view.
And do
So
they have
we
to
try and
pay
bridge the
to
gap.
be cared for in the hospice? Do you need to pay?
Well, the hospice that we run is free to those who cannot afford to pay.
I'd imagine there'd be a lot of relatives that would be just so thankful of having such a facility. There's a decrease of financial burden on them. The final days of their loved ones wouldn't be in a hospital, which isn't the nicest of environments, let's be honest. So there'd be a lot of people that had significantly benefited, I guess, from the services provided at a essentially free rate to the community.
That's right. I mean, we do get significant government funding. We raise significant funds in the community. But if somebody turns up and doesn't have the wherewithal, and there's a lot of people like that, then they get charged nothing.
Yeah.
And what that allows the families to do, and that person and their family or those close to them, is have some quality time, if you like, in the final stages of someone's life, rather than, as you say, in a hospital ward or at home where they're the carer, they're the provider. It's an enormously stressful and difficult thing for someone to do. Even someone who's experienced and, might have a nursing background, you're still got to do this 24/7.
Yeah.
So it's providing an alternative to all those other options.
All right. Well, let's jump a little bit into your legal practice and the type of work you do at the law firm. Can you tell us a little bit about your practice area and how you found yourself into that?
Look, coming from a small practice background, I did everything. I remember my father wouldn't do family law matters, and I decided I was going to do them almost as a student. So, 25 years of family law, a little bit of crime, lots of civil stuff, civil litigation, insurance matters. Property was a key to what we did. It's a key to a small residential practice. Tax, I was a tax agent for 40 years because historically lawyers provided tax advice and did tax returns. It's only been in the last 30 or 40 years where that hasn't happened, where accounting practices have proliferated. Before that, it was done in legal practices. And I suppose throughout that time, but in more recent years, it wills, estates, estate planning, and property. So just about everything, Hader.
Could I say that it almost sounds like you've dealt with the life cycle of your clients as well, as they've kind of gone through, you've kind of stuck with them a lot of the time. And now they're at that stage where a lot of them are thinking of estate planning or succession, or there's issues with their estates. So it almost feels like you've kind of gone through the natural life cycle of a human being.
That's exactly the way I see it. And that's how I sometimes present it, not quite that way, but in that manner to clients when I'm giving them advice. If they're 25 years old, there's a particular part of their life. If they're 45 years old, if they've got family or no family, if they're 85 years old, and all of the variations that go with life, I feel I've got some perspective on that to give them perspective, because that's often what people need. They need to sort of put themselves in a place they can understand, and then get proper advice about what their options are. So I think it's really important. And at a personal point of view, I really enjoy that, because discussing this with people, even if they're difficult conversations, it's something they need, and it's something we can provide.
Yeah. So tell us about some of the cases or the trickier matters that have come across your table in recent years.
Yeah, look, I've been thinking about that. In more recent times, it's been estates. There have been a couple of doozies. There's one which I'm in the process of finalising now, which has been going since 2016. We got a Court of Appeal decision. And essentially, it was last year in our favour. Second cousin disputing the will of his second cousin. Now, our client, died at the age of 100, and he's in his 70s during this process. And it was bizarre in the extreme in terms of the claims that were made as to how he had entitlement. But the one thing he did have was motivation and money. So he was able to essentially cause the estate 9 years of expense, significant expense, going through the court system with numerous sort of court applications and delays for COVID and trial delays, etc. Then an appeal, And then we won 100% in the end, which is always good, but it's very, very long, very expensive, very difficult process.
Any idea what was motivating him?
Look, he personally believed that my client's family owed his part of the family a significant amount of money and sums of money going back to the early 1900s, to the 90s and 90s in earlier family property transactions. He had a particular view about what had happened 70 or 80 years ago, and he was litigating that.
That was actually part of his case. Is that what you're saying?
It was a significant part of his case.
Oh, okay, interesting. So he was motivated by previous grievances between the families and felt like he had been wronged, and this was his attempt to kind of strike back.
That was it. Even though he saw his family as being wrong, because all these things happened before he was born.
Yeah.
But he saw himself as the person who was going to right all of the wrongs of the past. Now, most of those, I mean, they're not even within memory, let alone being able to be proved. Whether they were true or not, who really knows? But that was what motivated him. And there were a whole series of interactions between he and my client in the final 10 years of her life. There were some very dubious financial transactions, which the court reversed. So it was, at the end of the day, it wasn't not the typical family provisions claim that you see where someone is making a claim against an estate as a child or a spouse or partner. This was something different again. And he was claiming all of these contractual rights from the past.
It sounds like a severe case of victim mentality there, where you're talking about grievances that occurred prior to you even being born. If it was the case, and he was obviously advised by a legal team, how do you justify that as a solicitor to be running such arguments when, like you said, they're not even going to be in anyone's memory, let alone trying to find any kind of evidence to support some of those claims would be an absolute nightmare.
Well, I agree completely, but I suppose different lawyers have their own views on what their obligations are to their clients. You've got a client who says, well, this is what I want to litigate. I think I've got a right. I've got the money to pay you. Presumably, yes, I understand I could lose. But, part of the tactic was to wear down the estate, to wear it down, because I'm one of the executors, and the other executor is an elderly family member her health has been essentially destroyed by this process. And that was part of
He might see that as a win in his own right, the fact that he's been able to wear down one of the executors like that.
And have his day in court, over many years. And he was always someone who was going to have his day in court.
It's something that we've spoken about before, which is the legal system and how it provides avenues for remedying certain situations. But because those avenues are so wide and people are able to run their claims as they wish, I guess there'd be an issue with limiting people from running claims in the first instance. But the negative side of that, the flip side of that is you can really run costs up. You can really give an emotional toll to to people on the other side. And there isn't really anything to kind of draw that in or draw that back, because we've all heard these horror stories as lawyers and solicitors where litigation has just gone too far, maybe without enough grounds. But when people say, well, what can I do about it? How can I stop that? How can I prevent it? There's very little that can be done. And it's one of those things where it's like, well, we just have to kind of see this out. Do you see that as an issue, or do you see that something that's able to be solved without limiting people's claims in the first place?
Well, I agree with you completely. And that's what was going on here. It was just simply trying to grind the estate into the dirt. That's what it was about. People, as individuals, people have legal rights, and we're going through a phase in our society where people's own personal legal rights appear to be paramount to anything else, including the collective responsibility to our community. And I suppose we're seeing the extreme version of that now with this whole sovereign citizen process and conspiracy theories. All that leads to a certain amount of litigation, or a certain amount of defence time, or a certain amount of people challenging police rulings or magistrates. And as you would know, that's an enormous toll in the court system of that. And part of the tactic of those doing that is to wear down the system. To wear down the system, not just the opponent, but the opponent might be the state, to wear the state down.
So staying on that, I have noticed, and the stats show that there's been quite a significant jump in family provisions claims. Yes. So I think the numbers are about a 50% increase over the last about 20 years. Now, there's still, if you're to kind of average that out, you're like, okay, cool, I can kind of see that there's a growth in that area. Do you attribute that growth of family provisions claims to the fact that people now are a little bit more gung-ho and ready to go to court for these things? Or would it be more that there's more opportunity for these claims to kind of come about?
First of all, I agree with the numbers. I mean, they've just exploded in recent years, but the trend has been up for probably 20 years. I think it's because, firstly, people are living longer. So the wealth that it would have been held in someone's estate when everyone died at 65 is now not being realised to people in their 80s or their 90s. So, and that wealth is far greater because people live longer and because we're a much wealthier society than we used to be. And you constantly see those reports of what the transition, whatever the $1 trillion is being transitioned from the baby boomers across to the next generation. So all of those things mean that there's a much greater reason to do it. There's much more to fight over. And I suppose I sort of also come to the view that, a family, if your family's been going for 90 odd years, then, I think people get sick of each other, to be honest. There's much more opportunity. There's much more opportunity for family dispute if you think of it that way. If you only had to wait till someone was 65 and you're 40, then that's fair enough. But now you're going to have to wait till they're 95 and you might be 70 or 75 or 80 when you get your inheritance. And so there's an element where people just aren't prepared to wait. They're going to take their chop when they can get it. And so it's a much more aggressive thing. I think the other thing that comes into it is the greater complexities of families, which you would know well, and all of the versions of a blended family, such as it might be, and which always existed, but now exist in a much more complex way. That just means that there are so many more ways in which that can happen.
So, when it comes to estate planning, has that advice kind of changed over time where previously it would have been a certain type of advice because you're kind of expecting a little bit more of a nuclear family approach, let's say, as opposed to now? How has that changed for you as a practitioner?
Look, it was much simpler. It was much simpler. Now it's just so complex, and I suppose it comes down to what assets someone has. And if someone's going to have 10 or 20 times the assets of what their parents might historically have had, there is so much at risk. And so, obviously trusts and estate planning and the complexities of that, depending on where you are on the scale of wealth, is just, astronomically high. I mean, you see the classic cases of our power families in the media. Now, they always existed, but, Gina Reinhardt and the Packers and whoever else you want to talk about, they're at the extreme end. But at the much smaller end, there's still a lot that happens in estate planning to try and say to someone, well, if you do this and you do it well, then you'll reduce the possibility of those claims.
Let's talk about that a little bit more, I guess, more on a practical level. So what is the kind of stuff that you're seeing and what is the advice that you're kind of giving in those situations?
Look, how and at a simple level, how properties are held, whether they're held as tenants in common or joint tenants, people transferring wealth to their families or selected parts of their families before they die, much more use of trusts, both in wills and during people's lifetimes. Superannuation is obviously a key factor for many of us now.
Yeah, that's also recent changes as well, like relatively recent when you're talking about superannuation and the accumulation of that and the size of that. You would only start seeing that in the last 15 years, really, to see those large balances come about.
Well, that's right. Well, now, for many people, superannuation's their biggest asset. I mean, while housing prices have gone up and there's enormous values in our houses, for someone to have $1 million in super is not at all unusual. And in the future, the average person today is going to have, I don't know, maybe several million if you go far enough in advance. So that's a really important part. And from what I see at my end, most people don't have binding death benefit nominations for their super.
Yeah, I was about to get into that. So we are talking about superannuation, but let's get into the reason as to, I guess, why we're singling out superannuation and why that's different. Can you kind of run us through that?
Well, I mean, someone making a will assumes that they make their will and that covers all of their property and that, covers all the possibilities. It doesn't, because, property can be owned as joint tenants or tenants in common. Jointly owned property doesn't pass under a will. Or some forms of jointly owned property. That's a key issue. Trusts obviously aren't included in someone's estate, although control of them might. And then superannuation can either be dealt with in the will or separate from it. And so if you've done a proper binding nomination, then it's valid at the time of your death. It is much harder to challenge. So you can do lots of stuff that prevents challenges, at least when the first of a couple dies, much more difficult when the second of a couple dies.
Why isn't superannuation included in your will? Like, what's the reason for that?
Well, I think it has to do with the culture of super, and that's the way I explain it to my clients. I mean, the culture of super goes back to the 1970s and 80s, and essentially it was there for our families. And the traditional money earner was the male in the family. Now that's very different today, but it was there so that if the money earner died, there was something for the wife and kids or the family and the children to support them. That's what superannuation is there for, and that's what historically is the culture of it. So that permeates its way through the legislation, and that's why dependency, as defined under the Act, is a key aspect of how superannuation gets divided. Our dependents are the first line, if you like, of potential beneficiaries.
Yeah. That's something I actually wasn't aware of in terms of the culture around it and the circumstances as to why it was built in that fashion. But I guess what I was trying to ask was, why is it not your asset? You know, why wouldn't it just not be considered as something that falls under the will and as something that is like a bank account, let's say? And to break that down, when you say they're trusts, does this link back to your earlier point, which you're saying they were created as trusts because they were supposed to be vehicles that kind of pass through as opposed to just straight cash?
Not really. I probably haven't explained that very well. So I should say, first of all, most funds are trusts. I mean, there are government funds, and government pension entitlements, which are different, which are statutory. But the superannuation system essentially exists through Commonwealth legislation, which was enacted in the 1980s. Before that, superannuation existed, but it was limited, much more limited. And that legislation put in a regime of how superannuation was to be dealt with on someone's death. And that regime is still the same today, almost the same as it was then.
Right.
And so it was seen as something that could be treated separately, could be given separately, could be allocated separately to what was in your will, because dependents were the primary recipients of superannuation. They had a priority under the legislation, under the culture. Whereas under someone's will, it could be anyone. Now, quite often it's family, but not always. And then, of course, you come to what happens if someone has super but no family? Well, the ultimate beneficiary is the estate in superannuation. It's just that there's a hierarchy before that. So you can, depending on the structure of your family and who your dependents are, you can pick and choose who gets the super very effectively and very simply.
Yeah, that's really interesting because I guess, I didn't really understand that background and the history behind it. And that is important to understand how it is being built into society, because for me, it just seems like, well, superannuation, if it's almost like a savings account. Yeah, it's the savings account that I get access to once I hit the retirement age, and then it becomes my bank account at that point that I get access to. And I think a lot of people would view it in such a way, and that's why there's that confusion, I guess, when it comes to estate planning as to why it's treated differently or separately.
Look, I think that's right. And of course, if you're younger, then your focus is not on, what you're going to earn when you're in superannuation when you're 65 years of age. If you're 25 years old, then your focus is, a light years away from there. Now, it should be there as well, because super is something you build up over your working life, into a very substantial sum. So what tends to happen is that someone's appreciation of that grows as they age, because they get closer to that point, and we're all obviously more likely to die or become ill the older we get. So it's just a natural process of getting older. And so it's an intergenerational thing. The other thing with super, of course, is that you can have life insurance within the super fund, which many people have. And that tops up the super. So you'll often have a young person who'll say, oh, look, I don't have any super, and I've been working at Coles for 2 years. Well, they've got super. And quite often they've got life insurance as well that they don't even know about, which is a component of super.
And are they paying for that life
insurance? Yeah, they are. So and there's been some changes in legislation in recent years, so it's not quite the way it used to be. But, someone's employer will pay X dollars a week in super, and a component of that funds the insurance premium. And the idea is, of course, that, you might be in your 20s, but you still might have, family obligations, wife, husband, whatever, and a couple of kids, and your superannuation balance is low. So the idea of life insurance is it tops it up. So you might have 20,000 in super, but you might have $500,000 in life insurance.
And was that something that was conceived at the start?
Always. It's always been in there. And again, if you think about that culture of super, where it was originally to provide for our families, usually when we were younger, but that's all evolved. then when people are younger, they need, they don't have a superannuation balance the same as they're going to have when they're my age because they haven't been contributing or employers haven't been contributing for 40 years. So
Yeah.
the intent was then that you have a certain amount of superannuation and you have a certain amount of life insurance funded from your superannuation contributions, so that even if you're younger, you still have a significant balance.
Yeah. Well, fascinating, very interesting stuff, Gerard. I think we kind of delved into that kind of category, but I personally found it really interesting to see some stuff that I didn't know about in terms of the history and development and how it's here today. And I think it helps understand, especially, in most areas of law, especially to do with personal services, you are dealing with people's superannuation at some point. It could be, personal injury, family law, estates, so it does cross over into a lot of different areas.
It does.
And having that background really has helped me, I guess, kind of shape how I thought of it. Because I truly didn't understand how it kind of came about, but now the dots are kind of connecting for me. So I appreciate that. That's pretty much all the time that we have, but fascinating talk. I think we've got to continue it with some more follow-ups, but really appreciate your time and all the best, Gerard. Thank you.
Thanks very much, Ada. Happy to help in the future.